is Tim Lynch. I am your host of Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. We're brought to you live at the third Wednesday of every month at this time, 4 o'clock. If at any time you'd like to participate, you may feel free to do so. Our number here is 617-708-3290. Again, 617-708-3290. I asked a guest who was here a few months ago, who talked about the cases pending before the Supreme Court, and I asked my good friend Vickie Henry to come back because now we have the Supreme Court decisions, and I think it's helpful to go through these decisions to see exactly what was decided and what the relevance of those decisions are in the day-to-day lives of everybody in our community. So Vickie, thank you for coming back.
Thank you.
And Vickie, again, you're with GLAAD.
I am, Gay and Lesbian Advocates and Defenders.
And you guys are the people who do pioneer all this good work. In fact, you brought one of the you brought the first DOMA case.
That's right.
So, and that case was made up to the First Circuit, First Circuit ruled it unconstitutional, and then the Supreme Court took a case up from the Second Circuit.
That's right. That's right.
So that's where we are. The Supreme Court decided 2 cases. Let's talk quickly about the Prop 8 case, the Hollingsworth case.
Hollingsworth versus Perry.
Hollingsworth versus Perry, yes. Let's talk about that first, because I think that caused a lot of confusion, and there is still some confusion out there in California, at least confusion on the part of the proponents of Prop 8. Exactly what happened?
So in that case, some people who supported Proposition 8 and got it put on the ballot, when Prop 8's constitutionality was challenged, they intervened to defend the statute. And they were permitted to intervene at the trial court level. The defendants that were sued included the county clerks that didn't issue marriage licenses to the 2 couples that were in the case, the Attorney General and the Governor of California. And the Attorney General and the Governor basically said, we're not going to defend Proposition 8 because we believe it's unconstitutional. So there was a whole trial about what justifications might have supported Proposition 8, and the district court judge in the Northern District of California found that Prop 8 was not constitutional, and then the people who supported Prop 8, but not the governmental defendants, appealed. So the whole issue was, did they have a right to appeal? And then if they had a right, the Supreme Court would have answered the question of whether a state could restrict marriage licenses and kept them away from same-sex couples.
And it didn't reach that decision because the Supreme Court found no, what we call standing.
Right, legal concept saying you have to have been injured in a very specific way to be able to challenge something in court. And the people who supported Prop 8 were not injured in the way that the law requires. They had the same injury any other voter in California did. So the Supreme Court said they could not bring the challenge, they could not appeal that decision. And so at that point, the trial decision was going to go into effect and did go into effect.
Yeah, and the reason why the trial court decision goes into effect is because in that particular case, the proper parties were there.
Right, that's right.
The governor, the attorney general, and the court clerks. They didn't appeal it.
And even the Prop 8 proponents were properly before the trial court. It's just that they didn't have a right to appeal on their own.
Yeah. So that's good news for California. I know that there's some litigation still pending out there. They're trying to narrow that decision down to those couples.
Right. It is good news for California. I mean, essentially at this point, people are marrying. They started issuing marriage licenses in California around June 28th. And so people are taking advantage of their rights, and that's very exciting. The Prop 8 people would like the decision not to take effect, and so they've brought their own lawsuit trying to say that the trial court decision was either limited to those 2 couples or at least limited to the clerk's offices involved, and that they're trying to argue that the governor or the attorney general could not tell the other clerks in the other many counties in California to issue marriage licenses.
And lots of luck with that.
Right, that's right, that's right.
So, and apparently statements have been issued by the governor and attorney general of California. They're going forward with marriages. God bless them. People out there are happy. and just another free state.
That's right, that's right.
And now the other decision, the DOMA decision, which now those people getting married in California and in the other states where they can get married, we have the DOMA decision. So basically, what did the court decide?
So what the court decided there was that what's called Section 3 of the Defense of Marriage Act, which was a provision that defined marriage and spouse for all federal purposes. And it limited marriage to being between one man and one woman, and spouse to being someone of the opposite gender. And so the Supreme Court said, did Congress, why did they pass that? Did they have a good reason for passing that? And the Supreme Court basically said that the reason to pass it was animus-based, and they struck it down as being unconstitutional, as being a violation of equal protection and liberty interests that we have here in this country.
Yes, so it was animus-based because the House report that sent the bill out itself said they're making a moral judgment about homosexuals are immoral.
It did, but the Supreme Court really looked at, they said, well, what does this law actually do? And what it did was it created two kinds of marriages, and it created a first-class marriage, which is marriage for different sex couples, and a second-class marriage, which is marriage for same-sex couples. And it said those marriages of different sex couples would be recognized and protected and nurtured for all federal purposes, and we're going to disregard all the marriages of couples of the same sex. And so the question was, what was the reason for that? And that's where the court found that it was this animus space. They didn't have a good reason.
There was the lingo is there's no legitimate reason.
Right.
They had no legitimate
Right.
reason. The 4 justices dissenting, I imagine, found legitimate reasons, but
They did.
5 is a majority, and that section of DOMA is now struck. But it's interesting the phraseology there. First of all, it's only one section of DOMA that got struck. There's the other section that says states don't need to recognize marriages entered into another state. So I guess that's litigation for another day.
Well, it does exactly what you just said. It's a permission slip for one state not to recognize the lawful marriages of another state. I suppose it could be litigation for another day, but the fact is that states either have that power or don't have that power, irrespective of this law. So even though it's it's sort of a law also based on animus and that it's stigmatizing, it doesn't actually have any effect. If states have the power, they have the power. They didn't need the permission slip. And if they don't have the power, say because of the full faith and credit clause, then the Constitution always trumps a statute. So again, the statutes of, it's not.
It's basically
Substantive.
Meaningless.
Yeah. But what you have is that they have struck down this other part of DOMA that the federal government would not recognize the marriages. Is that at the oral argument, I think it was Justice Ginsburg was commenting that if you have these whole milk marriages and skim milk marriages. Yeah.
I love her. I think it's quite accurate, isn't it?
Yes.
And it also goes to the point where this applies to marriages, mind you, but not to civil unions. So even though people are in states where quote-unquote civil unions are exactly the same as marriages and all that other good language, and you always have politicians wanting to, find compromise. I don't know how you compromise rights, but compromise and find civil unions, and not give you the word marriage. Well, here, the word marriage has meaning, because if you're in a state that has marriage, you get federal rights. If you're in a state that doesn't have the word marriage, but you have civil unions, you do not.
Right. That's right.
So that's another argument for another day with places like New Jersey, where the court said that they have to give equal rights, and New Jersey passed a civil union law.
Mm-hmm. That's right. That's right. So we've already heard from the federal government that marriage-based rights are triggered by that status of marriage, that it is a unique status, and that those rights won't be triggered by civil unions or domestic partnerships. So that is about 7 states in the United States.
So we'll probably go through that. I just want to add my own little pet peeve, and I'm sorry. But, I love the fact that Justice Kennedy wrote about the children.
Yes.
And he emphasized it in oral argument. There are 40,000 children who are living in same-sex households.
I think that's just in California,
And that's
so it's a much
just in
larger
California.
number.
It's exactly right, in California. And of course, throughout the states, there are many. And marriage laws protect them. And people
That's
seem
right.
to lose that for some reason. I don't understand why, but they lose the point that the purpose of marriage laws and unfortunately divorce laws is to protect the children. And you have children in same-sex households, and they need these protections. And it bothers me to no end how that always seems to get lost in all this. And I was so happy that Justice Kennedy made a point of that, not only in oral argument, but in his decision.
Right. And, so glad because we did bring the first DOMA, this first strategic DOMA challenge and the first winning DOMA challenge, and we were in the appeals court first. We mapped out a friend of the court strategy, and happy to say that GLAD actually coordinated that strategy in the Supreme Court as well. We worked with the counsel for Edie Windsor, who was the plaintiff challenging DOMA, and we definitely made sure that different voices were coming to the table and that the voices of children were coming to the table to understand the impact of DOMA on them. And just to give you an example, a few years ago I was on my way to the office and I was reading this newspaper article about the dangers of unwed mothers and how they're bringing down society. And, I'm just, I'm on my way to work and I'm a taxpayer and everything. And I'm like 3/4 of the way through the article and it occurs to me, hey, they mean me.
Yeah.
Right? Even though I was legally married under the federal government's definition because of DOMA, I wasn't. And so here I am, I'm a partner at a large law firm at that time, raising these 2 kids in a very stable household. I mean, it's a good thing we're gay because otherwise we'd be so boring, it would be unbelievable.
There you go.
And I'm like, they mean me, Yeah.
So it's not only, and it's not only that, but it's also in many of these states that have allowed same-sex marriage, there's been a wonderful trend. And the New York Times did a great article about it last October, where 17,000 children have been adopted out of foster care by these stable homes, committed, loving, same-sex couple homes. The state no longer is paying to raise these children. They're being raised now in a stable, loving home. And, it's a new lease on life. And more to the point is these same-sex couples are adopting children that are considered, quote unquote, unadoptable.
That's right.
They're adopting kids who are older than 5 years old. So they're giving kids who, growing up in foster care, where they're moved around from home to home to home, a chance to have a stable, loving home. And if you don't understand same-sex marriage, what more do you need to know than the availability of more homes for children? And we have 500,000, over 500,000 children living in foster care in this country, that you have now additional homes that these children can go to.
Right. And in Massachusetts, you can be a same-sex couple and are invited in by the Department of Children and Families. They need new foster parents. People are retiring, they're aging out, and so they are looking for couples. So call Department of Children and Families if you think you'd be a good foster parent.
Yes, please do. I always say that's God's work, helping these children. But let's now get down to the brass tacks. What effect does this have on people? I mean, now you have couples who've been married in Massachusetts or Maine or someplace, and now they have federal rights. What does that mean?
So the DOMA had such a broad reach because it applied to over 1,100 federal rights and responsibilities. So this is huge, and it's an evolving situation as we see through this. So we're hitting some of the larger federal programs, and we're hearing from them. If you're a federal employee, there's already been guidance from the Office of Personnel Management that you have 2 months, a 60-day period to enroll your spouse in health care and the flexible spending account and the vision plan, et cetera. And you have 2 years if you're retired to tell the government you have a qualifying marriage and that you would like to elect your spousal annuity if you want to do that. It will affect people in terms of their health insurance if they have been paying for imputed income on the tax. In this country, we privilege health insurance for spouses and families. It's not taxed. You can use pre-tax dollars, but that didn't apply because of DOMA to same-sex couples. So